like to go through these documents with you.
Sure.
It's a pretty complicated process. Which of those is prepared first?
And let's identify which exhibit number if they're on those, or on the back of them.
Yes, Your Honor. So I have in front of me State's Exhibit 14, 15, and 17. The certificate of ascertainment, the certificate of vote, and the certificate of final determination of contests concerning presidential electors. Your question, sir, just to make sure I understood, is which the specific order in which they're created.
Correct. Walk me through the process of the three documents.
Yes, sir. Absolutely. They're started at different times and completed at different times. The certificate of ascertainment, the template is actually started before even election day. As we approach the election day for a presidential election cycle, by that point we'll have received the names of the primary and alternate electors so that we can populate the document, make sure that we have the template prepared, so that upon the conclusion of the Supreme Court canvass, all we really need to do is then add in the numbers of votes received by each of the applicable parties.
Let me stop you. We were talking about Exhibit
14.
14, and just so I understand in layman's terms, each of the four parties sent in 6 nominees, alternate nominees, and primary nominees.
Yes, sir. 6 primary, 6 alternates.
Okay, and then on this, you prepared it and you put the 6 nominees for each of the parties.
Yes, sir. That's correct. The 6 primaries.
Okay, primary is the original one. Alternates and primaries.
Yes, sir. And the distinction is simply that the 6 primaries are the ones intended to cast the electoral votes at the Electoral College. But again, in NRS 298, there's a clause where if somebody is an unfaithful elector and tries to vote for somebody other than who received the popular vote, they're removed, and then one of those alternates is immediately put into the position.
Got it. That's all figured out ahead of time, ready to plug in what I call the popular vote count.
Yes, sir. That's correct.
And so that was finalized on,
It looks to be finalized, sir, and based on the date of the signature, the 2nd day of December is when the governor and the secretary of state signed it. 2nd day of December of 2020.
okay, so by the 2nd of December, the correct number of votes had all been tabulated and put in.
Yes, sir.
Okay, and then you prepare this, or you or your staff,
Correct.
and then it goes to the governor
Correct.
with the numbers filled in,
Yes.
the numbers of the votes, and the Barbara Sagaski. And then this is a copy, but there's a lot of, there's a genuine seal on it.
Correct.
Okay. And that was Exhibit 14. Exhibit 15, which is the certification of final determination of contests concerning presidential electors. When's that prepared?
So this document, sir, is only prepared during an election in which there is litigation relating to the selection of the presidential electors. Case in point, this last year in 2024, there was not, so this document does not exist for 2024. But in 2020, because there was litigation, it ultimately was drafted by the governor's office, this one, and then sent over to the secretary for signature.
Okay, that's required by federal statute, state
Correct.
statute?
The federal, yes, sir.
Okay, and then that's dated what?
This one was signed by the governor and the secretary the 10th day of December of 2020.
Okay, because the Nevada Supreme Court had decided on December 8th,
Correct,
and then this says all litigation's complete.
correct.
What if it wasn't complete?
By the 8th of December,
Yes.
I will tell you, I don't know.
Okay. It's not filled out.
There's problems.
Okay.
Let me stop you right there.
Yes, sir.
Want to make sure Mr. Law sees the witness. My Zoom is bouncing back and forth between the empty chair and me. And that might just be an artifact of the workaround that we've done.
I see that it's showing on the witness.
Okay. Do you,
He's shaking his head yes.
he's shaking his head. Okay. All right, we're good.
Good, good. Third document is,
Oh, I'm sorry. Originally, these two documents were together. So I said State Exhibit 17, but it was actually State Exhibit 16 and 17.
okay, so you've got 4 exhibits before you.
That's correct. State Exhibit 16 is the certificate of vote.
Okay, and this is prepared on December 14th?
This document was prepared in advance as well. Again, most of the actual work to finalize them occurs immediately following the meeting of the Supreme Court canvass. We wait to make sure that there's no questions or disputes. As soon as the Supreme Court canvass was done on the 24th and just prior to taking the holiday, again, the document was populated with the names of the primary presidential electors, the names of the candidates for president and vice president of the United States who received the popular vote. And then also, that's when we update the timeline to reflect specifically when we anticipate conducting the meeting of the Electoral College. In this case, you can see it includes 8:30 a.m. Those are the details that are discussed and finalized following the Supreme Court canvass.
Okay, and when do the individual, now they're called electors.
Correct.
They were primary nominees and they turned into electors.
Correct.
Okay, and when do they sign it?
So that was signed during the meeting of the Electoral College.
Okay, so that's December 14th,
Yes,
2014.
2020.
I'm sorry, right? And it was by Zoom in 2020.
Correct.
Where were these individuals, the electors?
So it's my understanding that they may have been somewhere in Clark County while Secretary Sagaski and I were on Zoom. I was in my office here at the Capitol building. I believe she was in her office as well.
Thank you. And then the other exhibit is your letter back to Mr. McDonald returning the documents that were sent to the Secretary of State.
Yes, sir.
Exhibit 3 is the pack of documents from the Republican ceremony.
Yes.
Okay, and that's, your office received that, Secretary of State's office,
Yes.
okay, and you returned those,
Correct.
and you know that that's a same copy of what you had received.
Correct.
Okay, because even though you returned it to sender, you opened it and looked at it.
Correct.
Okay. And does that resemble anything like these official documents?
It does enough so that they look to be an attempt at a synonymous or similar type document. They do have a label in regards to the official ballot. There is, the certificate of votes, the fact that it's got the same title.
Okay.
There are other similarities though.
Okay, Did you think those were genuine documents
What do you mean by genuine? I'm sorry.
when you received them?
Right. They weren't our documents. They weren't the documents that were prepared by my staff and I, but they were documents that were sent to us.
Okay, and you thought they were farcical.
I think they looked like an attempt to duplicate the official documents, albeit on a shortened timeline perhaps. Yes,
Do you recall stating that the documents were farcical and really couldn't be viewed as fraudulent?
yes,
Okay, so you recall, you said that in an interview, correct?
correct.
That they were farcical
When compared to the official copies, yes,
and couldn't be viewed as fraudulent, correct?
yes,
Okay. And the Republican electors weren't pretending to be somebody else. correct?
Objection, Your Honor. I don't know if that's coming from a statement that Mr. McLetchie made, or if he's assuming.
It's coming from a statement Mr. Lawson made.
Okay. I don't know if he didn't ask it that way. He didn't ask
Oh, I'm
it
sorry.
properly. So I guess,
Witness who's asked twice, adopted the truth of it twice, there's been no testimony regarding when, where, why it was made. Any objection?
I guess just the form of the question, just objecting to form.
Do you recall being,
Oral.
do you recall being interviewed?
a number of times, yes.
Okay.
Do you have a specific time in?
So, 25th of February 2022 by Danielle Rhoda, an investigator for Attorney General's
I do.
office.
I remember.
Okay. That's what I'm referring to. And she asked, do you recall that she asked you when you received those, you conducted any type of investigation?
Into these documents?
Yes.
I don't recall her asking, but I'm certain she did if you have it in the transcript.
Okay. And do you recall that you stated that it couldn't be conceived that anyone would think these were official, legitimate documents?
That sounds like something I would say.
Do you recall that you stated that you talked to Deputy Attorney General Greg Zazino
Your Honor, I'm going to object if he's going into, Mr. Zunino was likely, and I believe, counsel for the Secretary of State, so any communications that he would have had with Mr. Zunino would be privileged.
or they shouldn't have stated them in his interview? Not privileged when I have them.
Wait a moment. Alright. Miss Engler, do you want to ask some questions in aid of objection to lay some foundation for that, to put it in context for me?
As far as Mr. Zunino,
Yeah, who he is, what the conversation was or wasn't.
the interview that you had with Ms. Rhoda, do you recall when that was?
It was when the allegation was came the first time, I believe, just said 2022.
Okay.
And correct me if I'm wrong, she's the investigator for the Office of the Attorney General. One-
In 2020, do you recall who the attorney was that represented the Secretary of State?
No, that was Deputy Attorney General, Mr. Greg Zunino.
Okay, and you had conversations with him following the 2020 election?
Yes,
And when you had those conversations, were you under the impression that those communications were privileged?
Absolutely.
When you were talking with Investigator Rhoda during that interview, did you believe that you were still discussing the contents of the communications? Did you still believe that it was under privilege?
I believe it had, and I seem to recall when she was in the room that we had legal representation there as well, accompanying me for that conversation.
And do you recall who was present at the time?
I don't, unfortunately.
Had the attorney representing the Secretary of State changed between 2020 and 2022 when the interview was conducted?
Yes, it had. I can't remember the exact date, but Mr. Zanino was essentially transferred to other position inside the Office of the Attorney General.
And so you had different counsel that you believe, it's your testimony that you had counsel present during that interview?
As I recall, yes.
Arnold submitted.
Okay, hang on just a second, because this is communications to a third-party, essentially investigator, instead of just to his attorney. Give me a moment. Okay, general rule of privilege regarding the lawyers 49.095, a client has a privilege to refuse to disclose and to prevent any other person from disclosing confidential communications between the client or the client's representative and the client's lawyer, or the representative of the client's lawyer between the client's lawyer and the lawyer's representative, made for the purpose of facilitating the rendition of professional legal services to the client by the client or the client's lawyer to a lawyer representing another in a matter of common interest. And then the 49.105, client's guardian, conservator, personal representation, people like that can claim the privilege. The lawyer at the time can claim the privilege, but only on behalf of the client. So, sir, the lawyer that was in the room was a lawyer for who?
Your Honor, it was a representation from the Office of the Attorney General for the Secretary of State.
Okay, and then you're being interviewed by an investigator from the Secretary of State.
Your Honor, I believe the investigator was from the Attorney General's office, or perhaps even Department of Public Safety.
If it was Ms. Rhoda, it was an AG investigator
Okay.
in the criminal division.
Mr. Zanino represents one or both of the offices?
So how the office works is there's a criminal side and then there's a civil side. There's different attorneys that have different agencies. So Mr. Zunino at the time of 2020 would have been the Deputy Attorney General or Chief, I'm not exactly sure what his position was, that was the attorney for the Secretary of State's office. His client would be the Secretary of State and subsequently.
And what was your understanding, sir, of the purpose of this interview?
An investigation into the circumstances surrounding the alternate slate of electors.
Any additional questions or information you'd like to elicit from the witness?
No, no.
this is these statements are being made in front of an attorney who represented a witness in some capacity or his workplace, but they're being made to a third party. I don't see how they fall within the privileges here. I'll overrule the objection.
Do you recall stating during the interview that I recall involving our Deputy Attorney General, Mr. Greg Zanino, and ultimately, because the statutes were so clear and the process is so clear on how it works, that this alternate set of electors and their documentation was almost farcical, so it wasn't even seen as a legitimate document. It wasn't seen as something that, frankly, could be considered even really fraudulent. Do you recall making that statement?
I do not, but it sounds like something I would have said.
Okay, was it true?
Yes.
Now, before you received the documents, and I'm talking about the Republican package in the mail in the Secretary of State's office, you already knew of the December 14 ceremony in the Capitol, correct?
Yes.
Okay. And you were aware beforehand it was going to occur, correct?
Briefly, but yes.
Okay, how did you briefly learn about it?
I can't recall whether it was in the news or what led to my being made aware of the ceremony occurring in front of the legislative building. Outside of the fact that I knew it was going to occur and that we had other business to attend to, so I would not attend it.
Okay, so you didn't attend it?
Correct.
Okay, and you were aware of it, and it was something open and publicly known, correct?
As I understand it, yes.
So as far as your office, Secretary of State's office, your Deputy Attorney General, no investigation was undertaken, correct?
As I'm aware, outside of the investigator in the interview you just cited. Yes, sir.
Right. Well, that was, a year later, someone else came and started an investigation, correct?
Correct.
You all had not seen anything that warranted an investigation.
Correct.
Sorry, I get feedback from that. You had seen the December 14 procedure on video, correct?
The Republican?
Yeah, I'm sorry, I didn't say that.
Yes.
But in front of the legislative building, there's a video that shows the Republican nominees
Yes, sir.
saying they are electors and signing it. You've seen that,
I
correct?
saw pictures of it. One electoral college per presidential election cycle is enough for me, frankly, but I was aware it had occurred and I have seen pictures of it.
Okay, did you see the video?
Not the videos.
Okay. You recall stating during the interview, the investigator said to you, you have already said that you determined the documents were fraudulent. And you answered, fraudulent? I'm trying to be careful about that. Because legitimately, it's no different than if, I have used this example before, I think. If my kid had written on the document certificate of election and then said, hey, Dad, I'm the governor now, I wouldn't go, oh no, I've got to file that, I guess you're right. This changes everything. That would just be cute and go on the refrigerator. But this is almost the same level of absurdness. So clearly, this is not. Clearly, this is not. Recall that?
Yes,
And that's truthful.
yes.
Courts and votes going all way.
Take your time.
Put the Zoom over here and the recording here. However you want to vote.
Yeah, just want to make sure we're still good.
Thanks very much, Your Honor. I've completed. I'll give you your floor exhibit. You want these up here?
I don't know what they are, yeah. No, it's fine.
You? Okay.
Can I have the 10?
You can, you don't have 10 as of now.
I'm gonna butcher your name.
Give me the first one.
Blushin?
Voloshin, that's correct.
Blushin. I recall in your interview you stated it sounds like it has a V, though it does not, correct?
Yes, ma'am.
Blushin. I'm gonna try to be good with this. My name's Monti Levy. I represent this nice young lady here, Eileen Rice. I don't think I've ever met you before, so it's good to meet you. Sir, you're pretty well versed in the election laws, correct?
I think so, yes.
Okay. Can you tell me, with regard to the ceremonial aspect of what are the requirements for the ceremony of the electors casting their ballots?
Certainly. So the ceremony itself, the biggest is that it has to be overseen by the Secretary of State. She has to run the meeting in that sense. There's a specific statute that requires that, again, RS 298. Beyond that, there's the oath that also verbatim has to be provided. And it also, between state and federal law, spells out specifically the actions in the vote that have to be taken by the electors. You can't have, for example, the electors vote for both president and vice president at once. They have to be two unique votes that are cast.
Okay. Your biggest requirement is that the ceremony, the voting, has to be overseen by the Secretary of State, correct?
Yes,
And on December 14th of 2020, that Secretary of State was Barbara Sagatsky, correct?
yes,
And she oversaw the democratic voting of the electors via Zoom, correct?
yes,
And you also were present by Zoom?
yes,
Okay. Barbara Sagatsky was not present, nor did she oversee the ceremonial votes cast by the Republican Party in this case, correct?
that's correct.
So the Zoom meeting, approximately what's the length of the ceremony?
Overall, I believe the meeting 15 to 20 minutes.
Okay. So 15 to 20, so not like an hour and a half or anything like that?
No, ma'am.
Okay. No singing?
No.
Just asking, is there pledge of allegiance stated before the meeting?
No pledge. I think the longest part is a little bit of history about the Electoral College that we do at the beginning to provide context to the electors. The entire process, again, not only being fairly unusual, but kind of an obscure thing that not many Americans are even aware exists. Secretary Sagatsky had asked at the time that we include that bit of history just to provide context for the extreme significance and importance of the event.
And even with that history, we're talking 15 to 20 minutes, correct?
Correct.
You testified with regard to the safe harbor date. Now, across the country, all states have the same safe harbor date, correct?
As I understand it, yes.
Okay. And I believe you testified that all election-related litigation has to be complete by that date?
As I understand it, yes.
Okay, that's not always the case, is it?
Not that I'm aware of. I mean, I don't know of any examples where it extended beyond a safe harbor date.
Oh, I'm sorry, were you done?
I guess.
Are you aware of a December 29th, 2020 filing by the state of Wisconsin to the US Supreme Court?
I'm not.
Okay. So, with your knowledge of election laws, can you please break down for me when the documents, when these official documents go to the archivist, the president of the US Senate, the chief judge of the federal court for the state of Nevada, and it doesn't get sent to your office because your office merely retains a copy, is that correct?
That's correct.
So you wouldn't mail a copy, wouldn't get mailed to the Secretary of State?
That's correct.
Okay. What happens with the documents, for instance, that goes to the federal district court?
So that part of it, the mailing, is very specific. The archivist has some very detailed instructions on how they want the packages mailed from across the country. We applied the same principles to the other 2 copies that were sent, not only to the President of the US Senate, but also to the district, the Chief Judge. Essentially, they don't want you, for example, to use, I believe it was routine USPS mail, for example. There's a very specific tracking process that they want done to make sure the documents arrive at a timely manner.
Okay, I apologize.
Please.
Okay, so my question was specifically with regard to the US District Court.
Right.
What does the US District Court do with the documents once it's received?
I don't know.
Okay, so you don't know, but you are aware of the election laws and what is required, correct?
Yes.
But you just don't know what happens to the documents once they're received by these other agencies.
The district court, I don't know. President of the US Senate, I'm aware of, having witnessed that, at least through TV, and then the archivist, I have a little bit of an understanding, but not specifics.
Okay, so tell me with regard to the President of the US Senate. You said you do have knowledge with regard to that. So tell me what happens with those documents?
So the documents that are sent, they require those to arrive by a certain date. They're then provided to the President of the US Senate, the Vice President of the United States, so that on the morning of January 6th, they have all of the official electoral votes cast from across the country. And you can see that different states have a chest or some sort of arc-looking thing to carry their votes ceremoniously into the chambers, and from then they're brought to the Vice President to read off as they tabulate the votes cast for the President and Vice President of the United States.
Okay, and so what does your office do with the copy of the votes that is retained by your office?
We retain them. There's a retention schedule, and then ultimately they move over to the archives, the state archives.
Okay, so is that what was done with the Democratic electoral votes that were signed and delivered to your office December 14th, 2020?
Yes, the official ones we didn't send them to ourselves like you said, but yes.
Okay, so fair to say your office did not do that same process with the documents that you received from the Republican Party?
Correct.
Okay. In fact, you returned those to Senate, correct?
Yes.
Okay. Now, I'm going to show you States Exhibit 10. Reference ones. Take a look at this. It appears there's copies of certified or registered mail receipts, correct?
Yes,
Is one addressed to your office?
yes,
Okay, let's take a look at that real quick. So the tracking number addressed to your office corresponds with a tracking number on page states 1041, correct? There's a tracking number right here.
tracking number. Yes,
Okay, so the tracking number for the Secretary of State for the certified mail, it corresponds with this tracking number that's on state 001041, and that is State's Exhibit 10, correct?
yes,
Okay. And can you read for me what is highlighted in the blue?
certainly. Highlighted in blue is refused.
Okay, so according to the post office, the mailing that was delivered to your office was refused. Is that what is
That's
depicted here?
according to the,
Okay, but your testimony was that you opened it and you not only opened it, you prepared a letter, correct?
yes,
You put that in the same envelope and you returned to sender.
yes.
So do you know why the post office states that your office refused that document?
I don't know the specific process by which the post office reconciles that sort of information, or if our return to sender is translated into a refused. I'm not familiar with that part of the process.
Okay. You testified, when Mr. Wright was questioning you, you testified that you previously stated that these documents were farcical. Do you recall that?
Yes,
When you opened them, you actually stated they were bizarro. Do you recall using that word?
I do.
Okay. In fact, you testified under oath in the Clark County grand jury on December 5th, 2023. Do you recall that?
Yes,
And at that time, you described opening these documents and looking at them and saying they were bizarro documents.
correct.
They didn't resemble the official documents. They were bizarro, they were farcical, correct?
Yes,
Something that your child would have written, "I am the governor," and you would put it on the refrigerator, correct?
yes,
You knew immediately when you looked at these documents that they were not official documents, correct?
I knew that they weren't the documents that we had created in our office. Yes,
Bizarro and farcical.
correct.
You were not tricked by these documents into believing that these 6 individuals were the official electors, correct?
I knew they weren't the original electors because they weren't the names on the original official documents that we prepared. Yes.
So you've never actually watched the video of the Republican Party's ceremonial vote done on December 14, 2020?
I recall seeing pictures of it. I do not recall watching it.
Okay, and in fact, at the time of your interview with the Attorney General investigator, you advised them of this video, correct?
Yes,
They had not known that there was a video, correct?
perhaps if that's what the testimony says.
You offered, in fact, to find a link to provide the video to them, correct?
If that's what I said, yes.
Well, do you recall or do you not?
I don't recall offering it to them, but I do remember not many people knowing about the video. I also recall that I think the video had been taken down at some point, so I don't know that if I was able to find or provide that to the investigator either.
Would it refresh your recollection as to what you told them about the video if you were to see a transcript perhaps of that interview?
That would be helpful.
Okay. I'm not asking to admit this, just to refresh recollection. if you have a problem with that, it's. We'll try to find the location first. Alright, I'll just have you look through it. So I'm gonna show you a document, it's 7 pages long.
Thank you.
And just read it to yourself and let me know if it refreshes your recollection.
Will do. If you want to skip ahead, you can go to page 6. Quickly read. Thank you for that, that helps.
Okay, does that refresh your recollection, sir?
Yes, ma'am.
Okay, so in fact, you did offer to track down the link of the video and provide it to the investigator, correct?
Yes.
Okay,
I do not recall if I was able to find it though, but
okay,
I remember offering.
okay. Now, we talked a little bit about the requirements for the ceremony. The requirements for the certificate of the ascertainments and the votes, those are required to have the state seal, correct?
Yes,
The documents that you received from the Republican Party did not have a state seal, correct?
that's correct.
There's a document that is required to be signed by both the governor at the time, Steve Sisolak, as well as Secretary of State at the time, Barbara Sagaski, correct?
Yes,
That's a requirement that those are signed by them, correct?
that's correct.
Documents that you received from the Republican Party did not have a signature line nor a signature, nor even their names attached anywhere in the documents, correct, sir?
That's correct.
I have no further questions, Mr. Chairman. Thank you, sir.
Ms. McLetchie?
I think Mr. Hardy's gonna go next.
Okay. And before you start, Mr. Blushing, are you okay? You need a bathroom ready?
I'm good, Your Honor, thank you.
Your Honor, I'm gonna go ahead and get these documents back to Mr. Lashley so that we can walk through some, if that's all right.
That's,
These are exhibits, I believe it's gonna be, those that they previously had were 14, 15, 16, 17, and 3.
thank you.
Thank you. Mr. Blashen, you can see you again.
Mr. Hardy?
You and I have worked together in the past on elections, is that correct?
Yes, sir.
And because of that, I know that you're very familiar with how elections work and specifically how the electoral college works, because you and I actually worked together on the most recent electoral college, did we not?
That's true.
And I was an elector in that particular one, I believe.
As you were, as my second.
So let's talk a little bit about some of the documents that you have in front of you, particularly the certificate of ascertainment. That's a required document that you have to submit to Congress as a part of the electoral college, correct?
Yes,
And in that certificate of ascertainment, it identifies who received each respective number of votes Republican from the popular vote, correct?
yes,
And so if there was somebody that were contesting the election, they wouldn't have that information because they're contesting the number of votes in there, correct?
yes,
And these particular electors did not have a certificate of ascertainment that was ever submitted in any form, correct?
yes.
Let's look at the next one, which is Exhibit 15. This is the certificate of final determination of contest concerning presidential electors. This is a common certificate that said if there ever is an election contest, correct?
Yes.
And in this particular one, there was no certificate of final determination of contest concerning presidential electors. That was submitted by the defendants, correct?
Correct.
And in fact, if somebody was contesting and continuing to contest the election, they wouldn't file this type of certificate, correct?
Correct.
So that would give somebody a reasonable inclination, right? That they would have submitted that document if there was an ongoing and continuing contest of the election, correct?
As I understand it.
Now, the next one is going to be Exhibit 16, which is the certificate of vote. You see that?
I do.
Now, this is the ballot, right?
Essentially, yes, or at the very least, the formal ballot. There's a ceremonial one, as you remember as well.
And I've got copies of mine, and I appreciate you making those for me. But this is the ballot that gets effectively submitted over to the three different places where they go. It goes off to the President of the Senate, it goes to court, and it goes off to the archives, correct?
Yes.
Now, this particular ballot, it has the state seal for the state of Nevada. And this is from the vote that was over, is that a yes?
Oh, yes, I'm sorry, I apologize.
I just want to make sure I have a clear record. I'm not trying to be rude or
I understand.
Thank you. And so in Nevada, and you and I have worked on lots of different election cases, Nevada allows for what's called provisional ballots. Do you recall that?
I do.
There's an entire section in 293 that allows for provisional ballots to be cast, correct?
Two sections, in fact. We use provisional, I won't opine on it, but we do use provisional for two different reasons in our statutes.
Those reasons can be because somebody has a right to cast it, they have some issues that they need to have resolved
Right.
by an election official, correct?
Yes.
And in fact, that's often the case where somebody will say, look, I'm gonna cast my provisional ballot, so that way you can, whether it be the county recorder, the county clerk, or even sometimes the secretary of state if necessary, to step in and look to see, hey, is this a ballot that should count or should not count, correct?
Absolutely, yes.
And so it's not uncommon in this state.
Hang on a second. Are you talking about regular citizen ballots, provisional, as opposed to the electoral ballots we're talking about?
I am, Your Honor, and I think we can draw the analogy, these were provisional ballots as well. That's exactly what these were contingent or provisional ballots, Your Honor.
I think that, I was only, I think you're going the same place, Your Honor. I mean, these are legal conclusions that they're arguing. He's trying to make analogy, that's legal argument. I don't think that's appropriate for questioning. I disagree wholly with what he's saying, but, you know, I think everyone knows that.
It's got some tendency that there's a difference between regular citizen ballots and these ballots, but these are the only ones that question in a process that a regular citizen's not even remotely, frankly, informed of. They're informed of the electoral college, that there's a process in general. Our electors do vote, but I mean, to the degree we're talking about. So I think the value of this line of questioning is gone because we're focused on this process and this process alone. I appreciate that distinction. So unless there's some other major point to it, I'd have to move on. I mean, is there something?
I can move on to the next section. Question, Your Honor. Isn't it true that underneath the elections division, it has its own investigatory body?
We do now, as of, after the 2023 legislative session, we now have two compliance audit investigators in the elections division.
And prior to that, there were investigations that were conducted by the Secretary of State's office, correct?
Yes.
And in 2020, there were certain things that were investigated by the Secretary of State's office, correct?
Absolutely.
And as a result of that, there were charges that were brought for violations of election law in 2020 for certain things that had occurred, correct?
Yes.
And I think you stated that, and previously testified, I just want to make sure I'm clear, that there was no election division investigation in this particular incident for violations of election law, correct?
Correct.
I have nothing further to add.
I'm going to follow up on one point there. Back in 2020, I believe I heard you say that there was investigations of other things at that time, despite there not being a formal investigation division within the Secretary of State. if that's correct, what type of things investigated?
Your Honor, I appreciate the clarification. So we did not have within the Elections Division compliance audit investigators or criminal investigators at the time, but the Office of the Secretary of State did have both elsewhere in other divisions. Our Securities Division, for example, has post-certified criminal investigators who, when the Elections Division identifies an allegation relating to any sort of misconduct tied to an election, campaign finance, et cetera, we would do an initial, essentially a civil review, and then turn those those cases over to the criminal investigators when applicable.
Okay, but back then, regardless, you didn't have those formal investigators, is that right?
We didn't have the civil ones, Your Honor, in the Elections Division, but the process still played out, albeit in a bit of an admittedly amateurish fashion on my own part to investigate it, but we still conducted investigations. When we identified things that made sense for criminal referral, we passed them on.
The defense has made the point that you didn't investigate these particular documents or this particular incident related to the December 14th matter, but in the mailings. I thought I heard you say that there were some other type of investigations that sprung up in that election. Just in general, what type?
In general, Your Honor, attempts to vote twice. We have a statute that says it's against the law to vote or attempt to vote twice. There were those investigations. We had questions about individuals that were not eligible electors because of either citizenship or maybe lived out of state. There were attempts to vote in our state and other states that we looked into.
Okay, that's sufficient. I was just presuming that. I just want to make sure I wasn't going off on a tangent. No brain. Thank you. You're complete, Mr. Hardy?
And nothing to follow up on.
Okay, thank you. Either back to Mr. Kelesis or Mr. Arnold.
No questions, Your Honor.
Same, Your Honor, no questions.
Redirect or
I'm gonna have some questions, but could we take a brief break? Like a 2-minute break?
Sure.
Thank you.
So go ahead. It's 2 minutes. I'm just going to chill. No pressure.
All right.
No pressure, all right.
Hi, Mr. McLetchie. I'm Maggie McLetchie, and I represent Mr. Jesse Law. I just want to make a couple of things clear. I think they were pretty clear, but I just want to make crystal clear. There were 3 documents that were required. There's the certificate of no contest, the certificate of ascertainment, and the certificate of votes, right?
Yes, the certificate of final determination is the third.
The final determination, is that the no contest?
Yes,
Got it. And you only received a certificate of votes from the defendants, right?
yes.
None of the other 2 documents?
Correct.
And they didn't sign anybody else's name on those documents?
No, that's not signed anyone else.
You determined those documents were invalid, and therefore you didn't have to keep a copy of them, right?
Correct.
Other than signing and/or sending the documents to you and to the other offices that you mentioned they were sent to, are you aware of anything, any statements about the electors and the election that the defendants made?
No.
You mentioned the video, we didn't watch the video, right? Okay. Your Honor, I don't actually think we need the witness for this, but I would like to ask to introduce to the court a copy of the Jack Smith special investigation and the reports on that investigation. I believe that it is admissible under NRS 51.155 subsection 3, which are factual findings made pursuant to authority granted by law, or are not considered hearsay and are admissible under certain circumstances, including against the state in criminal proceedings. I'm going to give you guys a copy. The section is NRS 51.155. It's public records is the title. Your Honor, Jack Smith was appointed special, he was appointed to do the investigation into Donald J. Trump's activities with regard to the 2020 election, and he made factual findings in an investigative report that I have a copy of if the court would like to see it. It's the report's titled Final Report of the Special Counsel under 28 CFR subsection 600.8.
How is it gonna be helpful to me?
How is it going to be helpful? Because he discusses the fact that the co-conspirators, Mr. Trump's co-conspirators, deceived Mr. Trump's elected nominees in the targeted states by falsely claiming that their electoral votes would be used only if ongoing litigation were resolved in Mr. Trump's favor. Indeed, the co-conspirators, those are Donald Trump's co-conspirators, withheld from the elector nominees information showing otherwise. This deception was crucial to the conspiracy, as many who participated as fraudulent electors would not have done so had they known the true extent of the co-conspirators' plans.
So, was it Jack Smith?
Jack Smith,
It's,
Special Counsel, U.S. Department of Justice.
Sure.
He did an intensive factual investigation into the alleged fraudulent conduct in the 2020 election and made a factual determination that the state electors were not part of the fraud.
because in his opinion, had they known, to use the earlier example from today, that they should have put something like, these are alternate in case of litigation, they wouldn't have otherwise signed it according to his opinion.
Because what he determined was that the co-conspirators deceived Mr. Trump's elector nominees in the targeted states
So,
by false.
so in the context of this one, the people above Mr. Chesbrough, or Chesbrough
Mr.
above?
Chesbrough and above. I think Mr. Chesbrough and above for the purposes of that investigation. I'm not sure that Mr. Chesbrough was not deemed part of the conspiracy by Mr. Smith, but for the purpose, what this determined was that the actual electors, including in Nevada, did not have any fraudulent intent. Indeed, they believed that they were only going to use the alternate elector forms if there was a legal resolution in their favor. That's a factual determination.
Did he investigate anything specific here in Nevada, or is he just extrapolating that from this higher level conspiracy, I'll call it?
My understanding is that he investigated from the higher levels on down and reviewed extensive documentation and emails and correspondence, including the correspondence we talked about today with Mr. Chesbrough and their communications with state electors.
Specifically.
Well, Your Honor, I mean, I have I have multiple objections. First off, this is a report that is issued by an attorney, so he's not a fact finder of any kind. He's certainly not a fact finder in the state of Nevada. Secondly, Ms. McLetchie's opinions or understandings as to what the contents of this investigation is not relevant. Additionally, this is based on his assessment regarding the president's conduct. It has no bearing on any specific determinations regarding Nevada law, which is what we're dealing with here. So I don't see how Mr. Smith's assessment, again, not a fact finder, has any bearing on what's happening here. Nor does it have any bearing on the witness who's currently on the stand, who is not Mr. Smith. I don't even know how Mr. Velashin would even know the contents of this document.
She indicated right up front that regardless of the witness, she was just going to offer this. I mean, she could have done it after he testified, so that issue aside, anything else?
And it's not, I mean, my understanding, a public record, there has to be some sort of, certification or indication of authenticity. There is nothing that I can see within this document that would meet the hearsay exception.
We'd be happy to provide the formal federal URL from which this was downloaded that that shows it's an official document. But to make clear that Mr. Smith was serving as an investigator, and his task was to evaluate whether there was any criminal conduct with regard to the transfer of power following the 2020 election. His determination was that the Nevada electors were not part of that conspiracy.
Your Honor,
So
I
he's
can address
making,
one
he's
other-
making an opinion of the ultimate fact that's before me.
Pardon me?
He's making an opinion about an ultimate fact that's before me.
He made a factual finding about the lack of intent of the electors in the states and having no fraudulent intent.
Your Honor, and if I can make one other, you asked about Nevada specifically, I can attest and tell you, as counsel for the NBGOP and for a number of people, we participated actively in this, responded to subpoenas, provided lots of documents. Nevada was thoroughly investigated by Mr. Smith. In fact, I spent multiple times back in DC working directly with Mr. Smith and providing all the information on the case.
So the fact, if I accept this for these purposes, the fact that someone who has never met these three arguably read about what happened, put it in national context as well, and said, if I were them, I wouldn't have done it had I been better informed. Is that the bottom line?
The bottom line is that they didn't have any awareness of any fraudulent purpose for the use of the alternate elector certificates, that their purpose was only to preserve the right to challenge the election, and that there was no desire to fraudulently overthrow the election. They were submitting this for a purpose protected by the First Amendment, to preserve their rights to challenge the election.
Did he? I'm going down a rabbit hole. Did he talk to any of them?
Yes, Your Honor.
Who talked to him?
Mr. Smith,
He took testimony.
His investigators took all the testimony.
Back in Washington,
So,
D.C.
wait a minute, of your actual clients.
Correct.
Okay.
We
So
actually.
the statute, Miss Engler,
Yes, Your
any
Honor.
reason to believe, I guess, have you seen that, been presented with it before?
Well, no, I mean, I was handed to it 5 minutes ago, so.
Any reason to believe that that's not the document that it purports to be, I guess, coming down from a URL from the government website?
Your Honor, I believe counsel to be honest people, but I was handed this the same time that you were.
Okay, so.
do you want to download the?
Hey, hang on.
I'm sorry.
He's special counsel, Mr. Smith, so he's either a public official or part of some public agency, is that correct, according to your offer of proof?
Correct. He was appointed as independent special investigator to independently manage any investigation and prosecution to ensure independence and accountability in particularly sensitive matters. He was appointed by Attorney General Merrick B. Garland.
In civil cases and against the state and criminal, factual findings resulting from an investigation made pursuant to authority granted by law, which it appears he has, come from unless the sources of information or the method of, or circumstances of the investigation indicate a lack of trustworthiness. Not having verified the URL, it coming up late. Frankly, I mean, you can mark it and admit it. I'm focused on these defendants, their intent, the documents in this case. His opinion, frankly, weighs very, very lightly in my mind. due to frankly the partisan politics across the country about this and how it drug on, I don't doubt that, you know, it's a serious matter. He investigated it, he came up with it. I'll admit it, and I'll use it as some corroborative evidence from the defense's perspective. But it's, I gotta stay up front. Haven't read it, I'm gonna take it at face value, your representations of that key portion. You can cite that key portion in case I wish to look at it, but the helpfulness to the court, the relevance, assuming it's a proper application of NRS 51.155, it arguably tends to make a fact of consequence more or less likely. You've got the balancing test, the prejudice. There's some prejudice given the general nature of that investigation against the state and its utility. I'd have to find that it substantially outweighs the probative value. Can't really say that, but again, I'm just gonna be upfront. Well, it is some small piece of a picture. That's it at the most. So you can mark it as exhibit. I think we're down to I, either H or I.
I would just point out for the record that he was appointed by Mayor Garland, and any partisan influence on Jack Smith would have been the opposite of finding no culpability.
Still doesn't mean anything.
Understood.
So next topic to discuss was this witness as opposed to that document.
I have no further questions. Oh, I did. I have no further questions.
Okay.
Pardon?
Mr. Arnold, last chance?
No question, Your Honor.
Okay. Redirect.
Very briefly, Mr. Washington, in your role as Deputy Secretary of State, do you communicate with your counterparts in other states?
I do frequently.
Are you familiar if there is a national certificate of vote that all states use? In other words, is there the same ballot form for all the states?
Oh, no. In fact, I do remember that coming, the guidance from the federal government is that there's requirements, happens to have the chief executive's name, for example, chief election official must sign online, but they specifically do not mandate a template to be used across the country.
So there could be 50 different versions of the certificate of votes that are coming from the states.
I believe there are.
Okay. And so you reviewed the documents that were submitted by the defendants,
Yes,
and you formed your opinion as to the quality of those documents?
yes,
But the other agencies, they receive documents from all of the different states,
yes, that's correct.
and presumably they're all different.
They are.
Nothing further.
Is this witness free to go? Okay.
Yeah. And just one further question, Mr. Balash, what knowledge do you have of other states? Are you an expert in other states' election law or just an ex?
So, ma'am, the saying is if you know one state's elections, you know one state's elections, but I have looked at the archives page as we were developing our certificate of ascertainment. The archives page lists in alphabetical order all of the other states. So, for example, I've had a chance to look at the others. Curious to see if there were template recommendations that I could make to the secretary as to make ours better, more ceremonial, those sorts of things. So I haven't had an opportunity to look over the majority of the other 50 states.
Okay, thank you. No further questions.
Just wonder, Mr. Lashin, isn't it true that those other states, all of them come in with a seal on them affirming that they are correct, true and correct?
As I understand it, yes.
And these ones did not, correct?
Yes.
Anything else? Sir, you are free to go. You can remain in the courtroom, go about your business. The rule of exclusion is still in effect. So you're not to talk to any other witness about the subject matter of your testimony, questions you were asked, answers given, exhibits used until you know that this particular hearing is over. Don't allow others to do the same. Of course, we're free to talk to the attorneys involved if you need to, or if they wish to ask questions. Any issue with that?
Your Honor, I do have one clarification. One of the defendants is a fellow election official in our state, and I want to make sure that I'm still able to conduct our business in preparation for the 26th election cycle with him.
That would be me, Your Honor. I represent the NBGOP, and we can still talk about anything that not related.
As well as Mr. Hindle.
Yeah, I understand.
Yeah, the information just can't spill to any other witness involved so that their testimony would be tainted. They'd be tipped off to strategies, topics, facts. So, no, if you have independent business, no problem with that. And that was with Mr. Hardy.
I'm sorry, I just remembered one further question. I apologize, late in the day, but I get less smart later the day goes. Mr. Velasquez, you mentioned, I believe Mr. Wright was asking you questions that you were interviewed by the Attorney General's office on multiple occasions, is that correct?
I'm sorry, could you repeat the question?
I believe you testified when Mr. Wright asked you about the interviews that you had with the Attorney General's office about this case, that you were interviewed a number of times, is that correct?
Your Honor, I'm going to object that those beyond the scope of my redirect.
In the interest of completing this witness, not having him be recalled, just even though he's courtroom released, he hasn't left the courtroom. Go ahead and answer.
Thank you, Your Honor. So I've been asked questions about this repeatedly, the events surrounding the 2020 election cycle. Interviewed by the Office of the Attorney General at least once that I recall. I believe there were other individuals, I don't remember if they were reporters or not, that have asked, but I have been asked questions about 2020. It just doesn't seem to stop.
About how many times have you been asked about 2020 by the Attorney General's office?
That I can recall, once formally through or twice formally that I recall. Once with the investigator, I think she investigated or interviewed me twice, as I recall.
I'm sorry, the investigator interviewed you twice?
I believe so, but perhaps it was just once with a follow-up, maybe.
Okay, thank you very much. No further questions.
Okay, that's it. You're free to go with those admonitions.
Thank you, Your Honor.
Ms. Engler.
Your Honor, the state has no further witnesses and will rest.
5:30. We can try and press on. There's some late information and issues for me to digest. We can try and press on for the evening. I don't know if the defense has witnesses, how long they'll take, and then how long argument would take. So I'm looking to everyone for thoughts where we go from here. It's now 5:30.
I'm too old. I second that, Judge.
Should we do this now, though? Okay, that's fine.
Say,
Obviously, Your Honor, my position would be to complete today. I don't have lengthy arguments. I don't know if they're intending to call witnesses or not. So,
What I'd like to do, I'd like the state to contact Mr. Langford. I'm told that he listened in, the attorney for Mr. Cheslow.
Chesbro.
He won't speak to the defense. They control the witness. I'd like them to get him to testify here tomorrow. Meaning Mr. Chesbro. What I said, Chesbro.
Jeez.
what legal authority do I have to force that?
I can't control he won't talk to me.
If
They had, Mr. Langford was listening this morning to the proceedings. The attorney, Mr. Cheslow, I understand they sent him the link. And so they are controlling a witness, making him unavailable to me.
What do you have to say they're controlling him and making him unavailable other than the fact that they released him a few days ago?
That's what I have. And they have, I don't even have the plea agreement. They never produced it, okay? But I would say in the plea agreement, he's obligated to testify in this proceeding.
The same?
Your Honor, I'm fairly certain the proper agreement was in the discovery. There's no actual plea agreement that exists, so But we released Mr. Chesbro. I guess we're going back in circles. We released Mr. Chesbro. The defense had every right to subpoena him. They did not. This is now the time for the preliminary hearing, for which they insisted happen on these dates. They chose not to subpoena him. That's not the state's responsibility to go fetch a witness for them.
There was a plea agreement in the proper session. There was a break so he could read it, and he was questioned about, do you understand it all? Now she's saying there's not a plea agreement.
She says there was, and she thought it was included.
There's an agreement not to charge him. That's not a plea agreement.
It's not included in the discovery.
Okay, well, he's not here nonetheless.
All right,
On the
how about a
record,
continuance? We got sandbagged.
on the record I have before me, best case scenario for the defense giving them every benefit of the doubt. There was a continuance, there was reference to, I believe, Mr. Chesbro's, my recollection is hazy of that at this moment, but I think we talked about it, his potential availability or not. I've not heard of any specific promises that he'd be available. In a case like this, it's one where it gathers media attention. I would expect if the witness is that key, there's 6 defense attorneys, a subpoena would go out just to cover their tail, just in case. I did that as a prosecutor, as a matter of course. I know that's not very persuasive, but it's a preliminary hearing. They don't have to call the witness. They can release them. There's no reason, legal reason they can't. And they, like I said, absent a promise, we're going to keep him. One could argue there's an air of sandbagging, but I can't find that they did that. It's intentionally to keep Mr. Chesbro away. And I can't think of any authority I can force them to. I can ask them as a courtesy if they wish to reach out, email Mr. Langford, or Mr. Is it Langford?
Langford, yes.
Or Mr. Chesbro, see if they wish to talk to you. But I can't force a witness to talk to you. If this was a domestic case and the victim didn't want to talk, they don't have to. I mean, period. I don't know how I can do that. I don't know if any specific legal authority, if I had facts that the state was intentionally hiding and intentionally making them unavailable. Absolutely. As far as a continuance, to try and get him here, what would you expect him to say that would be helpful and offer proof in that regard?
That these people are innocent. He would also testify that he did not violate this statute, that he was named as a co-conspirator in. He would testify he had no intention to defraud. He wrote all of the documents, he provided them to these people, and his actually testimony over there in one of those documents is, I didn't intend to deceive anyone about what these alternate slates of votes were, and the electors who relied upon my documents didn't intend to deceive anyone.
Yet he wasn't having the strength to stand up and tell them himself, you should put in additional language. I mean, from earlier, he caved to higher ups. I mean, so how much weight is that going to add for me?
I need you to hear his testimony. I want to call him as a witness. I thought he was going to be here. All I'm asking is, they won't assist. They let him go. They won't cooperate in any fashion. They want to suppress his testimony, is what's happening here. And I'm asking for the opportunity,
And
because we didn't know he was gonna be here.
I'm not going to, for Ms. Engler, bite off that there's an intentional suppression. But what, if any prejudice, is there, other than time and money, to try and find a date for all of these calendars, give them an opportunity?
Your Honor, because this is it's the probable cause hearing, it's preliminary hearing, it's slight or marginal evidence, and Mr. Chesbro's opinions as to what his thought process were do not reflect on the intent of the 6 defendants. So when he gets up here and he says what he wants to say, which, by the way, I've been quiet on the characterizations of what Mr. Chesbro's gonna say, because the reality is all of this was contingent on a legal litigation going forward, which wasn't done at the time, or which was concluded in Nevada at the time. So that was an important factor for Mr. Chesbro, but at the end of the day,
What do you mean by that? I'm not following.
his position relied on there being pending litigation. And there was no pending litigation in Nevada. And that is what he has testified to. So all of his opinions and everything that they're saying were based on the fact that if there was pending litigation in Nevada, then this should happen. There wasn't pending litigation in Nevada at the time. But it doesn't really matter, because at the end of the day, this is a probable cause hearing. It goes to intent. There is specific Nevada case law that says when one is in possession of a forged instrument and seeks to pass it, it's permissible to infer, for the purposes of establishing probable cause, that, in this case it's she, acted with the fraudulent intent necessary to support a charge of forgery. So the fact that they were in mere possession of a forged document, which we're getting into argument, I understand. But for probable cause hearing, this court can infer that intent's there. Those are questions of fact for the jury. So my argument to the court is I don't believe it's necessary for these proceedings, based on what the case law.
Thank you, Ms. Lee.
Yeah, I just wanted to respond to what Ms. Engler just stated, that Mr. Chesbro would testify that the pending litigation was necessary. He actually would testify, and we provided this, the state has this, they provided it to us initially, that Mr. Chesbro in an email stated that court challenges pending on January 6th really are not necessary. And there was an entire analysis that he gave on that. So he would testify that a pending litigation was not necessary on December 14th, 2020 for an alternate slate of electors. So I think Ms. Engler, by stating that he would testify to that, opened the door to this other information, that he would testify in fact that it was not necessary to have pending litigation on December 14th, 2020.
His opinion is an expert witness, essentially.
Well, he's an attorney, and
I know lots of attorneys, I'm
No.
not listening to much of what they say.
as a, the state stated that he would testify that pending litigation was necessary, and that's why he felt that Nevada was a problem, but that's not what he would testify to.
But that's his memorandum, that was the summary.
And it was given to us by the state, where he states that pending litigation is not necessary.
Okay.
This is also alleged as a conspiracy, and that a group of people were doing a thing together that was an intent to defraud, and he was part of what they were doing together. And so what the plan was and why they were doing it, his testimony is relevant.
As to what though? I need a specific.
His testimony as to what the purpose was of the alternate elector forms that they're assuming is forgery because in their view it contained a false statement. So his view of what they were doing, whether they were intending to defraud is an element of the crime, Your Honor. And this, his testimony helps undermine the allegation that there was any intent to defraud.
Okay, so kind of the question I posed to Mr. Wright earlier when I initially denied, I think it was Exhibit A or Exhibits, I think now they're C and D, And I'm talking to Ms. McLetchie.
Sorry.
I used you as a frame of reference. He said, represented to me that Mr. Chesbro talked to his higher-ups. They said exploited that, don't do it, and it never went down to the clients. So how does his opinion help when it's not conveyed to these individual folks?
If it's the state's position that not including conditional language may be somehow a forgery, which we'll get into the argument whether it's a forgery tomorrow, I suppose. But if it's their position that not having that conditional language is relevant to intent, I think it does matter that the only reason that another state, for example, had it was happenstance. Additionally, it explains that they would have had it just if it were not by the happenstance of Mr. Chesbro and Mr. Roman saying the expletive that he did. They did not include the conditional language because the essence of forgery is intent to defraud, to get one over on people. Forgery, in my mind, you don't sign your own name. Put something off with somebody else's. For example, if they had tried to attach a certificate of ascertainment signed by Secretary of State Barbara Sagaski, that we would have a different case here. But to me, the lack of conditional language, I believe, is something the state depends on. The state also depends on this theory that if they lost at the Nevada Supreme Court on December 8th, that they couldn't still have been considering challenges to the United States Supreme Court at that point, unless they literally immediately filed their petition for writ of certiorari. They got testimony today that about when those election contests ended, whether the election was really done. We had testimony today about the Safe Harbor Act, and Mr. Chesbro's testimony will explain what the status was with. He didn't know whether they were. He didn't get a response to his email about whether they were pursuing litigation, but he can testify as to whether they had to file on December 9th, 10th, 11th, 12th, or 13th in order to have a valid challenge to the United States Supreme Court pending and to still be considering litigation. So to the extent that Ms. Engler just testified that there was no pending or active litigation, that argument's false because they could still be considering potential litigation at the United States Supreme Court level, and his testimony helps explain that. Central to their theory is that there was no active litigation. In fact, they had, in front of the grand jury, they had somebody testify that they had exhausted all their remedies, which was false testimony. And so it's relevant to have Mr. Chesbro talk about what were the options on December 14th. Was it possible to still, was it their view as a group, and then we're working together on this the certificate, that there was still potential challenges to the United States Supreme Court?
Thank you. Shawn, restate your position, please.
Your Honor, I'm gonna reiterate the fact that Mr. Chesbro's opinions, or for lack of a better, his theory on what processes that they could follow and not follow, it's not actual law, and it's his opinions, and that's not reflected on the state of mind of the defendants. And so for purposes of this proceeding, and we're in justice court, slight or marginal evidence, everything that they're trying to allege goes to intent, and for what we've charged, which is uttering the forged instrument, intent can be inferred by simply possessing a forged document and then passing it. And that's
It can be inferred, of course. I'm familiar with the statute, frankly read it last night, preparing for today, but it's a permissible, exactly the word I was using, it's a permissible, and there's hotly contested information over intent to defraud here. His opinion about it, if the relevant facts are what he did and what was conveyed to these individuals, because I'm looking at them and their intent. So he thinks not, but he doesn't convey that.
Well,
I'm gonna take a moment
well,
and dwell on that, because that's gonna impact what we do, whether we continue it or we come back tomorrow for either defense case or argument. So,
one additional thing on the offer of proof for Mr. Chesbro, I would get my exhibits in, all of his emails, because in his emails, he answers these questions. Literally, one of the questions was, is there litigation pending in Nevada? And it's not in, I'm making an offer of proof, it's one that was, they won't stipulate to, even though they put it in the grand jury. And in fact, tomorrow, I'm gonna call one of these two as witnesses to get my offer my exhibits and lay the foundation. You can only admit admissible evidence before the grand jury. These documents have all been there and they were properly admitted. But as far as having Mr. Chesbro here, we could get in our defense case, is what I'm asking. The documents I haven't been able to get in, because Mr. DeGraffenreid referred him to Mr. Bunnell about the ongoing litigation. And he also testified.
so those documents show what? Duplicative testimony, or that?
Not duplicative, I couldn't get him in.
Well, if he testified, theoretically, if he's here and he testifies to it, what is the utility of the particular emails? I mean, he didn't tell these guys that, so why are the emails coming in?
Well, the email would come in because the ones that I want in, it shows what he was telling them, from which you can infer his state of mind. He asked, is litigation still pending? And this isn't in evidence, because it's one of the emails that they don't want in. Mr. DeGraffenreid responded and referred him to Mr. Bunnell, their lawyer, regarding the litigation to go to the Supreme Court. And he'd also testified on these dates in the litigation. He filed his, and the court can take judicial notice of this,
Okay.
of Mr. Chesbro.
Okay, thank you. That's enough on this issue. I'm
Yes, sir.
gonna take a moment, collect my thoughts. Whether we're continuing or coming back with the defense case tomorrow. Thank you. Okay, thanks. Please be seated. Sorry it took so long. Trying to talk through it in my head, put it in context. The issue before me is continuance. Come back another day, have an opportunity to see if Mr. Chesbro can be subpoenaed and then show up and offer testimony or go ahead tomorrow. The arguments in favor of continuing, as I understand it, are from somewhat of a 10,000 foot level. Mr. Chesbro would arguably come in and say something to the effect of, I'm somewhat of a master architect to try and find challenges to a election for my party. Part of that, I'm trying to keep people out of jail, trying to orchestrate a method to do that within a legal framework. And that's what I was trying to do when I drafted these particular documents. This is all by offer of proof, and right or wrong, how I've kind of distilled it into my head. And then the key time frame, and because these events took place on the 14th, would arguably be anything that may or may not have happened or could have happened, or could have happened between the 8th, when the Supreme Court of Nevada said your challenges are not going anywhere, and 6 days later, on the 14th, as an offer of proof, Mr. Chesbro reached out said, hey, what are you doing? Because it might have some impact on how I arguably advise you. On that offer of proof, Mr. DeGraffenreid says, talk to my attorney. And it appears that the information, the emails, are just going to back that up, corroborate it. But nothing happened between then and the 8th. These people that are accused in this case went through with the 14th for whatever reason. Mr. Chesbrough coming in and saying that, and this is just my words, trying to put some of this together, I'm trying to keep people out of jail and challenge elections. That's his effort. He's not their attorney. They have one, or at least arguably, according to the offer, Mr. DeGraffenreid had one as a go-between and other advice. Arguably, if that opinion is admissible, and I didn't think they were violating the law, in light of a likely question, again, from earlier, when I asked what did he act on it? Did he tell them, put a giant red sticker on these documents that says, hey, this is temporary? And he chose not to. So his opinion about things that may or may not have happened in that time frame and his likely efforts overarching to keep anyone in any of these states out of jail is it's got some relevance, if it's admissible. I'm still thinking about that, but it's not persuasive, frankly, at this particular moment in my mind. I haven't heard anything prior to this in quite a bit of leeway to allow arguments on it, to make representations about anything else specific. So thinking about that, bringing him back for that, in light of a situation where he's not here, to continue it, to try and get him here, I have to think, frankly, that his proposed testimony is of more significant value than it appears right now. And I'd be somewhat endorsing the lack of a subpoena here to make sure he shows up. The state's got no duty to bring him. It appeared they wanted him. At one point, he was discussed at the last continuance hearing. There's definitely reason to believe that he would likely be here, but simply because the party has a reason to believe someone is likely to show up, and granted, this is someone who doesn't want to talk to them, I'll take that at face value from defense representations. Cuts both ways. I mean, all the more reason to slap a subpoena on him just in case. Strategies and ideas change when push comes to shove at an actual contested hearing. Bottom line is I'm not going to continue it. I can't find that the state is withholding him or did anything improper by releasing him. So we'll come back tomorrow. We'll have defense evidence, if any. They have no burden or requirement to present any. So it's either going to be defense witnesses or argument tomorrow. So the question is, what time do you want to come back? We can start as early as 8. We can do 9. Probably a good idea with the travel to length of today's hearings, but I'm entertaining ideas on when to come back tomorrow.
I have no preference, Your Honor.
Nine,
That's fine.
9 o'clock?
Okay.
I prefer 9, so we can,
No firm opinions being voiced by attorneys. So
9 o'clock.
9 o'clock, it'll be an issue regarding Mr. Law, was under the assumption he wasn't feeling well.
I believe Mr. Law's trying to travel tonight,
Alright.
so that he can be here tomorrow and can avoid any issues.
Okay.
Is there any way we could start at 9:30 tomorrow? Because I think he's getting here very late tonight.
Okay, the state's rested, so if we have time to get it done before 5, I mean,
Yes.
the health staff late today, I don't want to do it tomorrow.
I mean, obviously, I'll be here as long as the court requires, but I would like to start so that I can try to be on a flight home. I do have children.
Yeah, what time is the flight scheduled?
Our flight is scheduled for, like, early afternoon. It's not like the morning, but
Any suggestion, as to how long you think your case might be? I mean, and I can't hold you to it, I won't hold you to it.
Not very long.
Okay.
I think we'll be mainly arguing it.
Okay, let's shoot for, I hate it when judges split the baby. 9:15.
Thank you, Your Honor.
I detest it, but I did it. So see you at 9:15.
Okay.
Thank you.